Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann. Shauna Sanford is away on assignment. Thank you for joining us today. We're continuing our discussion on Stand Your Ground and whether such laws help or hurt in terms of individual rights versus safety, inside or outside of the home. Last week we began our discussion with our guest, Judge Calvin Johnson. Judge Johnson has returned for part 2 of our series on this topic, and when we come back, we'll jump right back into the conversation. So stay with us.
I am for the child who lives in motels, cars, and shelters, now in foster care, a group home, where he sleeps not on a bed, but on a temporary cot. He is the child I am for. I am a CASA volunteer. I am you.
Hello everyone, welcome back to the show. Today we're continuing our discussion on Stand Your Ground laws. I am joined by the Honorable Judge Calvin Johnson, who spent 18 years on the criminal bench. Judge Johnson retired from criminal court in 2008, and today he serves as the Executive Director of the Metropolitan Human Services District. Judge, thanks so much for continuing this discussion with us here on episode 2. Stand Your Ground laws, very much in the news because of the Zimmerman trial. In Florida, but law is very similar here in Louisiana, right?
Absolutely. We have law here very similar to what's in Florida.
And we talked about it at some length in our first episode, defining it and giving some examples of it. Today, let's go into a little more detail. Critics of Stand Your Ground laws argue that it increases violence. And do you have an opinion on that?
Well, there's studies that show that and you can see both sides of it in the studies. Some studies that show that in fact you see an increase in violence when compared to what was before. Other studies that show that in fact what you see though are people who are utilizing the law correctly and therefore operating correctly under the law, and you see then less violence as a result of the law. So studies go both ways.
Right, and like what they say about statistics, right? They can show
anything
you want them to show. Well, I'd like to put a graphic up on the screen which shows case outcomes. It's where what was it? Florida Tampa Bay Times actually did a study, and they determined, looking at 200 cases in Florida, that people who stood their ground, so to speak, and committed a homicide, only 32% ended up being punished or either being convicted or doing a plea bargain, and but 68%, that's 113 cases, they were not punished. And so that gets back to that reasonableness standard. A district attorney makes a determination first. Does he or she think that this maybe the person in the home that got invaded was acting unreasonably, or maybe it happened out in the street, and he might not prosecute or she might not prosecute. Or if it's prosecuted, the jury may acquit and say, I think you acted reasonably. Just like Mr. Zimmerman was acquitted by a jury.
Absolutely, and actually, even before you get to the prosecutor, though, the police, the sheriff determines, based on their investigation, that the act was justified, and so no arrest is made. Keep in mind, initially in Zimmerman, no arrest was made.
Wow. Because
the police, sheriff determined, or from their look at law, that there wasn't a basis for an arrest in the Zimmerman case.
Okay, so. Well, obviously, the law does prosecute people who the DA, well, first the sheriff, then the DA determines perhaps they did not act reasonably, and many of those 32% end up with a guilty verdict or maybe a lesser charge. You can be charged with murder, but it could be reduced to manslaughter in certain cases. Or they reach some sort of plea verdict where the person accused of violating Stand Your Ground's limits agrees to plead guilty to some charge, either the actual charge or a lesser charge. So the reasonableness standard being applied there did they violate stand your ground laws? Did they operate within stand your ground laws? Correct?
Exactly, John. And that's the kind of analysis, when you look at statistics and you look at an analysis of cases, what you're also looking at is how the law, that is either from the police standpoint, the DA standpoint, a grand jury standpoint, how they interpreted the law.
We have another graphic to follow up on this discussion. We'll put that on the screen. Interesting, and it says in these statistics also from the Tampa Bay Times research that nearly 70% using stand your ground have gone free. Also, that defendants claiming stand your ground are more likely to prevail if the victim is black. 73% of those who killed a black person face no penalty compared to 59% of those who killed a white person. And finally, the statistics that they came up with at Tampa Bay Times said that 2/3 of the defendants used guns. Now, defendants in this context means the person whose home is being invaded, or said that his or her home was being invaded, or maybe they felt they were being attacked out in public. These statistics show certainly that there's a disparity in the race question. Do you believe that have you seen similar things happening in Louisiana? You're 18 years on the criminal bench.
Well, race always matters. And when you look at criminal law generally in America, you see the same kind of thing play out. If the victims are black, if the victims are black, you see a different kind of result. If the defendants are black, you see a different result. Those things play out regardless of any other consideration, regardless of any other kind of crime you're talking about. Race matters.
Right.
But also, money matters. Because you also see, and this is consistent in criminal law wherever you are in America, but defendants who are well-financed or well-funded have a better result in a criminal court than defendants who aren't. So that also plays out in this. You can't ignore race. You can't ignore money.
And criminal law is not my area of law. When I practice, I'm doing more personal injury, but I'm very familiar with it. And going back 25 years, when I did a little criminal law defense work at Loyola Law School, in fact, you were one of my mentors.
Yes.
It is absolutely true that if those people who have good defense attorneys are going to have a better outcome than those people who simply cannot afford a good defense attorney, and they might get some young, inexperienced or less experienced lawyer through the court-appointed system.
That's a fact. I mean, you can't ignore those facts. That's absolute fact. And what's also true in so many instances, the government prosecuting cases, or this particular case, and we saw this recently in federal court, but can't go toe-to-toe to the well-financed, well-funded defendant with unlimited resources. That defendant, in so many instances, and not all is too big a word, but in so many instances, that defendant wins, regardless of what the actual fact and circumstances are.
And each prosecutor has a huge caseload, typically speaking.
Exactly.
So they're responsible for doing a lot of prosecutions, handling a lot of pretrial motions in the court, and if they're being really outgunned by well-paid defense attorneys.
Exactly.
Motions to dismiss evidence, motions to exclude confessions, all kinds of things. They can, the defendants, the more times they swing the bat at beating the rap, if it's in fact a guilty person, the more likely they are to succeed.
That's just true. That's absolutely true. So when you analyze the results, you have to look at, sometimes you have to look at race, it matters. You also have to look at resources, because that also matters.
Right.
And so when you come up, then when you're looking at statistics and cases, the surface look may be misleading in terms of what the actual reasons behind the result was.
Excellent point. And on that same note, even President Obama recently just was saying how the way people perceive you, and if you are an African American and maybe the defendant, or the person who's alleging they stood their ground is white, they may have some conscious or even subconscious reasons to believe they're more in danger because they see a black person coming into their home or into their space.
We have those notions, and it crosses race. Obviously it does, but you also see similar views with any racial group. You see it across different ethnicities. in terms of Hispanics, in terms of Asians, in terms of blacks, in terms of whites, and how these things play out. We have perceptions. We see the kid in the hood, in the hoodie, going approaching us, and it's a darkened street, and we think, oh my God, I need to cross the street.
Yeah.
Well, that plays out in both the white community and the black community. What we do, though, as regards that kind of encounter, may be different. Right. And when we in fact go as far as Zimmerman went in that kind of encounter, obviously that is a huge difference.
Sure, sure. And that almost leads right into this profiling discussion. Mm-hmm. Why don't you define for our viewers, what is profiling? We heard a lot about this.
You know,
in the Zimmerman case.
It's when we have a general notion of what the bad people are. Generally, the bad person is black. That's our general belief. Is Hispanic. That's our general belief. Is Asian. That's our general belief.
People different from us.
Is different from us. Is different from us. Is young. That's a belief. Mm-hmm. Is in a certain kind of car. That's a belief. Is in a certain neighborhood. That's all of those are beliefs. Okay. And all of those form our reason for believing that this person, because he fit those general definitions, this person presents a danger. Right. And therefore we do something based on that belief.
Okay, and in the Zimmerman case, it appears that Mr. Zimmerman saw somebody who fit a lot of those.
Exactly.
And he thought he had to go up to
mm-hmm.
young Trayvon Martin wearing a hoodie, and then the altercation ensued with a very sad result.
Absolutely, absolutely. And so he took that to the ultimate end, whereas some other person similarly situated may have taken it to a point, but not to the ultimate end.
Okay. There's some statistics I want to put up on the screen. This is an interesting discussion about weapons comparison. The victim, that would be the perhaps intruder, or the person who was in the wrong place at the wrong time, or the person who knew he was in the wrong place, versus the accused. That's the person who committed a homicide and says he or she was standing her ground. The statistics are somewhat surprising that out of 192 events, 113 of the intruders were unarmed. They had no weapon on them. And the accused in those same crimes, obviously they used a gun, 121 out of 192 events or episodes. Obviously, of the balance of that 192, subtracting the unarmed 113, they might have had a knife, they might have had a gun, they might have had some other weapon. But very often, what's that saying is somebody who was in the wrong place at the wrong time, either intentionally or accidentally, is not carrying a weapon.
Exactly, exactly. And again, the person who pulls the trigger believed that their life was in danger. Right. And now the question comes whether that's a good faith belief.
Yeah. And I want to be clear too. It's not saying that the accused knew that the person was unarmed.
Exactly.
And that's what you're getting to. In other words, somebody's intruding into your house in the middle of the night. You're not going to conduct a full interview while you may have a gun pointed at you. You may be completely justified in defending lethally yourself and your family.
Absolutely, without any other question asked, because of the behavior of the person whose life now is taken, but because of that person's behavior, there's no need to ask any other question. Right. But pulling that trigger is the ultimate act. And again, you can't take that bullet back.
You can't take that bullet back. We need to take a break here. Coming up next, we will take your questions. Please stay tuned. We'll be right back.
I need help finding a doctor.
PACE.
I needed help with my medication.
PACE.
I needed help getting around.
The Shirley Landry Benson PACE Center is a place that helps seniors remain in their homes, providing the care they need. If you or a family member are over 55 years old, you may be eligible for benefits offered by PACE. For more information, contact us at 504-835-0006. PACE, caring for those who cared for us.
Welcome back. Every week on the show, we like to get our viewers involved in the conversation. So we're continuing that discussion on stand your ground and taking your questions. Let's get to those. One of the questions that was sent in says, if I'm not at home, can I stand my ground in public?
Depending upon what the event is, depending upon where this thing takes place at, depending upon what actually happens. Yes, the answer to that question can be yes, absolutely can be yes.
Right, and it's the same sort of analysis you said.
Yes, because there is a but, and but becomes a big word. It becomes a very big word.
Right. So if you're merely, walking down the street, or you're standing, you're at the park, and somebody puts you, what you believe to be in some sort of serious danger, you or your family with you. As long as your perception is reasonable, and other people would agree that was reasonable, you may use stand your ground, and there's a little likelihood you'll be prosecuted, or if you're prosecuted, there's a very good chance you will be found not guilty.
You may use lethal force, but you have to recognize that once a life is taken, the circumstances, the situation is going to be microscopically analyzed to determine if, in fact, your action was justified. Right. Because, again, that's the ultimate act.
It's the ultimate act, and we don't want people to think that this is licensed to just go back to the days of the Wild West. In fact, that's what a lot of the critics are saying. Exactly. People think, well, I'm just standing my ground. That guy looked at me funny, and I saw that he had a bulge in his hip pocket, and I thought maybe he was going to do something bad, but nobody's reaching for anything. Nobody's saying and doing the things that say, I'm going to get you. These things go under the microscope, and please, in other words, the cautionary tale here is, do not use that kind of force if you have any reasonable means of avoiding it.
Absolutely.
Leave the scene. Absolutely. Walk away.
The fact is that once we walk out of our house with a gun in our pocket, that's a statement we've made. Yeah. That's a statement we've made. And so everything else comes as a result of that initial statement we've made because we left our house with a gun in our pocket.
Yeah, things kind of escalate. If you've got a gun and you think that other person has a gun, you may be thinking, well, if I was in that guy's shoes and I saw somebody with a gun, what would I do? It's generally a bad idea to walk around with a weapon. It could go off accidentally, and you could cause serious harm, never intending.
In the number of instances when that accidental shooting happens, Allegiant, seemingly every day.
Yeah,
there's another
all
one.
The time.
Every day.
Well, on that note, there's been a lot of talk about concealed weapons and people carrying concealed weapons. In fact, there's nothing preventing from people who are entitled to carry a gun, that's everybody basically, but felons, from carrying a gun that's not concealed.
And that's something times which totally lost in the conversation, is that in America, there's never been a prohibition against carrying a gun, visibly carrying a gun, walking around with a gun. And then when we go in country areas of Louisiana, we see people all the time with guns.
Well,
they have them in their trucks, they're very public. Because there's no law that says you cannot possess a gun visibly. Right.
Well, we're so pro-gun in this state that they recently passed that gun amendment, which double reinforces everybody's constitutional right to bear arms. In fact, that may put into conflict some of the other laws that say you're not supposed to bring a gun near a school, you're not supposed to carry guns in certain situations.
Sure. Or you can't carry a gun concealed without a permit. Well, maybe now you don't need a permit to carry a gun.
And there are actually people debating that. There have been people raising defenses to criminal prosecutions, which previously I think most people agreed were a good idea. They're raising a defense that the new constitutional amendment conflicts with these other laws on the books. And if the other laws are not also constitutional amendments, they are less powerful than the constitutional amendment, and the constitutional amendment can invalidate those other laws.
Even a convicted felon. Because there are now cases in the Supreme Court where the Supreme Court is looking at whether, in fact, even a convicted felon can be forbidden from carrying a gun.
Well, we have a graphic to put up regarding stand your ground laws in America. 25 states with stand your ground Florida-style laws. 7 states have extended the use of deadly force outside of the home, and only 18 out of the 50 do not have stand your ground type laws. So we're kind of a pro-gun nation by those statistics.
Absolutely, no question about it.
Yeah, and blue states and red states, they have differing statistics as well. Let me ask you a follow-up question. In Louisiana, well, actually, let me get to the next question because it relates to the discussion. Interesting question someone sent in: can kids stand their ground at school or on the playground?
Wow.
I mean, I'm picturing maybe a young teenager carrying a gun.
I mean, how you get to a gun on a school campus? I mean, that in and of itself
Right.
would be in violation of law. If
you're at the public playground, maybe you're not using a gun. Maybe you're using a baseball bat, and a blow to somebody's head with a baseball bat could
It's
kill them.
lethal. That could be lethal.
Yeah. So, are kids entitled to invoke these laws if they believe they're in danger?
The law doesn't discriminate in terms of age, so it wouldn't matter the age of the person who is saying my act is justified. It wouldn't matter age.
Wow. And so, hopefully, anyone who has children, you're taking the time to teach your children about gun safety. Hopefully, maybe you're teaching your child, allowing your child to have a gun, but they have very good teaching, I hope, that tells these children just how deadly these guns can be if they're not taken seriously and not carefully handled.
Absolutely, absolutely.
All right. Let me ask you one more question. If an intruder, someone you perceive as an intruder is banging on your door and refuses to go away, do you have the right to threaten to shoot if they don't leave your premises?
Wow. Again, firstly, call the police. But secondly, tell that person to leave your premises. Thirdly, though, if in fact that person is not only banging on the door, but in some kind of way, form, or fashion is coming through that door, then you may be justified in taking action against that person, including taking that person's life. That question, though, or the answers to that question is so dependent upon all the fact and circumstance that surrounds that incident.
Okay. Here's a question that I like. It says, is there anyone who cannot claim stand your ground? This writer says, what about undocumented visitors, illegal aliens, visitors from other countries, people here on a work visa? Are they entitled to use the same stand your ground defense?
That's, again, a good question. My knee-jerk answer is yes, they are. Yeah. Because I don't think the law would discriminate against them simply because they're not. That person illegally here would have other issues. Illegally here has other connotations.
And maybe illegally in possession of a firearm, but they're not going to be in trouble for a homicide if they acted reasonably.
Absolutely.
You agree with that?
That could be the case.
Right. Here's a question from Shirley. How can a judge use discretion to determine what part, if any, of the stand your ground law should be permitted or allowed as a defense by the jury, or even if it's a judge case, by the judge?
The judge would have to, the defendant would have to put forth things within the case, either by a plea itself, the plea itself defense, that in and of itself would raise some reason for the judge to give a jury charge as regards that defense, but also something else presented in the case in terms of witness testimony, testimony that comes either directly from a witness or indirectly by cross-examination, but gives the judge a belief that that defense should be given in terms of a jury instruction.
Here's a related question. If someone is presumed to be a threat, but they have not yet done anything to provoke an altercation or a fight, how can the other person try to claim stand your ground?
Again, knee-jerk, no, they couldn't.
Okay.
Because simply perceiving a threat with nothing else, no act in furtherance, nothing in furtherance of that perception that one has. I can't perceive, John, that you are a threat to me,
right,
and then do something lethally as regards that perception without you doing something else, saying something, taking some other action that gives some credence to my perception.
A little bit of local politics. Recently there was in the paper a local elected judge who said she perceived from a defense attorney that he was threatening her. This was in the courtroom, and this gentleman was using words. He obviously was not brandishing a weapon, and she sought to hold him in contempt and put him in jail for 24 hours. That's not a stand your ground. Is that a stand your ground type argument?
No.
Okay. All right. Another question. if you what level or type of force is allowed to understand your ground? Are you allowed to use a certain amount of force to defend yourself in certain situations and lethal force in others?
Sure. You depending again on the circumstance and situation, how far you can go in terms of your reaction to it. Are you still allowed to go to the ultimate distance in terms of reaction, regardless of what the perception was in terms of threat? If you say I'm going to punch you because I don't like you, that does not give me the right to shoot you.
Right.
That still does not give me the right to shoot you. I have to have some belief, something that gives me a reason to believe that my actual life is in danger. Now, arguably, punching me may be great by maybe putting me in the
It's got to be reasonable. You got to be able to
reasonable.
demonstrate it to the satisfaction of the DA, the judge, the jury, in order to not be found guilty of homicide.
Exactly.
Homicide. Well, a fascinating discussion. I wish we had hours more time in order to cover it, but we're out of time for this show. We want to thank you, Judge Johnson, and we want to remind our viewers, don't forget, you can watch this episode and previously aired episodes on our show, on our show website, johnredmondpoa.com. Don't forget to like us on Facebook, please, and follow us on Twitter, and to keep sending in your questions. Thank you so much, and we will see you next time on John Redmann, Power of Attorney.